Mrs. Clay respectfully requests and order that Mr. Clay be now ordered to be responsible for 100% of Shanta's college education and the attendant expenses. The child should be entitled to at least as much education as her parents receive. The court should receive evidence on the cost upon her acceptance of decisions as to which college to attend. Unfortunately, even though she is more than an adequate student, plans have not finalized at this time. To avoid future trips to court to resolve the education expenses for the two younger children, Mrs. Clay requests that these issues also be resolved at this time. The younger daughters will not be going to college for some time. By the time they reach that age, Gloria expects to have income enough to pay for half of the expenses for the college education of the younger children. Mrs. Clay requests the court for an order to the effect that she and Mr. Clay will each be responsible for one half of the education costs and attendant expenses for the two younger daughters. The management of the CDs in the Busey Bank in the sum of $3,000 in the children's name and earmarked for their education should be given to Gloria for management and reinvestment, if for no other reason than the lessons learned when Ernest was given the rents to collect and the confused and partial explanations he had to offer to support his stewardship. Loans for mothers. This is an inherently suspect area of testimony. Even in the cases where the parties and one of the mothers haven't boasted their credibility by treating the court to schemes to borrow and loan the deductions on property without regard to the federal tax niceties, the flavor of some of the evidence is such that one touches it at possible risk of getting wet ink on the fingers. Gloria's testimony, as elicited by Mr. Goldstein, exhibits only one acknowledgement of debt to Mrs. Toms in the sum of $2,000, of which she claims that $300 was repaid. This squares with Ernest's admission, see above, of the $10,000 debt to Mrs. Dunham by the parties in connection with the acquisition of the house. It is our suggestion that you regard none of the other claims of debt to relatives as having been proved, and allow any real indebtedness to be tested by the willingness of the parent to forgive or collect it. This may not be worthy of Solomon, but it recognizes the free and easy givings of the parties and their parents. It puts a premium on accounting, formal notes, and other kinds of conduct consistent with loaning money to children rather than just helping them out. It is the least the court can expect where you are asked to collect suspicious loans which smell more of divorce than of any original intention to seek repayment. Find this one not to have been proven. Miscellaneous. Even though Gloria can't claim a reimbursement for the enormous sums spent prior to the March agreement, she is still out of money. Consequently, she is unable to pay any state of Illinois tax liability and requests that Ernest have sole responsibility for any such liability. Nor does Gloria have any funds to pay Christy Clinton. He should be awarded any indebtedness. Regarding the ambulance bill, Ernest had control over the insurance claim process, so now should not be allowed to claim the delinquency of the debt is Gloria's fault. Also, the ambulance was necessary for preserving the health and safety of his daughter. Mr. Clay should be ordered to pay the ambulance bill. Water bills, newspaper advertising, and power bills for his property, 1503 South Prairie, had to be paid by Gloria contrary to the March 5th order, as is provision in order to get the vendors to give her future service relative to her own property. This amounts to $457.74. Assets to be divided. One of the major inequities in this case is the fact that for over a year following the breakup of this marriage in February 1986, not one cent of support was paid by Mr. Clay. Certainly, Gloria received about $2,400, but this was described as part of her share of rental income, not as support. During this time, whatever support, private education, or other needs were met by Gloria alone. This should be taken into account in a major way when allocating the property. Gloria should be awarded one half of the CDs in the Champaign First National Bank in the amount of $15,000, especially in view of the heavy burden of expense she has borne without reimbursement, such as the summer camp, the private schools, and the medical expenses not reimbursed. In addition, the parties should equally divide the Chicago CDs and the property on Michigan Avenue. In the alternative, if it is desirable to let Mr. Clay have these items because of their involvement with other members of his family, a makeup call is merited for half their value of approximately $60,000. Mrs. Clay also asserts that the purchase of a car for the daughter has set her back $5,000. The awarding of attorney's fees and CPA fees in this case are another matter. Attorney's fees are already considered to Jack Laura are one element, and counsel has been paid $3,000, and on a total fee of over $8,000, which will be pursued by a motion attendant to this proceeding. The CPA fees are obviously an essential in a case such as this, but most of the accounting was done by memory and in 12 different checking accounts, not to mention some works worthy of a Pulitzer Prize fiction in the form of financial statements. Conclusion. This case presents extreme difficulty in conceiving how the court will allow the remaining property until some real value of the partial as-is exchange is achieved. Any speculation that it was equivalent does not seem to square with the confused nature of the negotiations between the parties, including the disputed December agreement covering some points. Frankly, this is a mess. It is difficult to get out of at this point without accepting Mrs. Clay's observation that it was engendered by Mr. Clay as the draftsman and moving party for the agreements, as the fiduciary who has not explained the absence of large sums which the property of Mrs. Clay should have yield, and as the party who has sworn on financial and tax documents to own property he here denies. It would seem that these unresolved issues should be taken against him wherever they occur, and that Mrs. Clay should prevail on all disputed issues. Respectfully submitted, Gloria Clay, plaintiff, by Robert Auler. Auler Law Offices, PC, 202 West Green Street, Urbana, Illinois, 61801, 217-384-3080.